Okay, so the free exercise clause, which is actually the second part of the statement, you can't prohibit the free exercise of religion. So the big question for us is, does that mean free exercise of no religion as well? Right? And I split this up a little bit, partly because there's another kind of test that comes in here for whether or not this applies, and I'm going to do it right in the middle of the cases. And there's only 4 or 5 cases here, so it's not a big deal. And then we'll take a short, more fun break. And again, look at the year on the first one, 1878, so right after the national government takes precedent over the state government. This is the first time they were called to interpret the free exercise clause, the extent of it. And it was about a polygamy case, right? And what scared the hell out of them was the idea that anybody could found a religion, one person, make any laws, and say, this is my religion, and it scared the heck out of them. And I mean, think about the ramifications of that. You could have the Druids or pagans that are doing animal sacrifices or human sacrifices as part of their religion. You can't stop them. They couldn't stand the thought of that. So what they came out with was, you can't interfere with mere religious beliefs and opinions, but we can interfere with practices. So they've kind of killed the free exercise clause at that point. So this is back in 1878. And look at the next date. It wasn't really challenged until 63. So for close to 100 years, it stood that the government couldn't stop you from believing how you want to believe, but they certainly could control how you practice it. And just on the surface, I kind of understand the argument. You certainly don't want anybody to form a religion. And it wasn't until the Warren Court, which is in 63, and the Warren Court actually went from 53 to 69, and it's Earl Warren, if you haven't heard of him, was the Chief Justice during that period. And it wasn't until that period that Warren was actually able to come up with some ways around this. It was a case called Sherbert versus Verner in 63 that caused this. And so this woman had started a job, and then 2 years after she started the job, and she was a Mormon, I think, or Latter-day Saint, the company changed the rules and wanted everybody to work 6 days a week instead of 5. And she refused to work on Saturday. Not allowed to. They fired her. Okay, she took that and applied for unemployment insurance. And a few of these cases are about unemployment insurance, which is interesting too. She applied for unemployment insurance and they denied it because she was fired from the company on grounds of her behavior at the company. She wasn't just, it wasn't just let go because of staffing or whatever. So she sued, and the Supreme Court heard this, and in a 7-2 decision, they came up with this test called the Sherbert test. And so we'll look at that. And it's this first one that is which gets around the last problem. So whether the person has a claim involving a sincere religious belief, maybe a little bit vague, but it allows them now to say people have the right to practice the way they do as long as it's sincere, a real religion. That gives them a little bit of control over it without having some obscure religion say you can do any odd thing. It's fairly clever. It's a little vague, but it's fairly clever. The second part of it, so if you look at the top, it's the court must determine these two things before they can even look at the second part. Whether the government action is a substantial burden on the person's ability to practice that belief. If it's a minor thing, they have no reason to continue. It has to be a substantial, burden on the person. So in this case, it's an established religion, fairly prominent in this country, actually worldwide more in this country now, I think. So it certainly is a valid religion. It's not like one person in a garage somewhere. And this was stopping the woman from practicing her belief, and said that they ruled in her favor based on this. The second part of the test, though, is so if those two elements are valid, then the government must prove these last two. One is that it's acting in furtherance of a compelling state interest, so it has to be trying to accomplish something for the state, right? And that it's pursued that interest in a manner least restrictive to the person or to the way they practice their beliefs. So these 4 criteria were then used for a certain period before they got challenged to determine whether or not this clause applied. Make sense? So now we're back to, I put the clause up there again so you can see it. So now we're back to some cases that actually, and it wasn't challenged for quite a while, but we're back to some cases that now get to use the Sherbert test to determine whether or not they're valid, right? So the 1991, we looked at the very first one. This is an Indian guy and one white man, and they were using peyote, I think I'm pronouncing that right, which is a hallucinogenic drug that the Indians use for religious purposes, right? But they were in a drug rehabilitation program and not allowed to use any drugs, right? So they used peyote for their religious purposes, and they were, so they were, I think, ended up going into jail because they were part of this rehabilitation program and used drugs, right? It wasn't just that they went into jail. So they were part of the rehabilitation program, and then they actually started working there. And it was after they started working there that they used the peyote. Okay, so they were fired, ended up in jail for a while. The jail didn't work out, but they were fired and they lost their unemployment insurance. So they went and sued for that again. And here's where the court says, it is a permissible reading of the Free Exercise Clause to say that if prohibiting the exercise of religion is not the object of the law, but merely the incidental effects, and now we're talking primary versus secondary, right? Incidental effect of a generally applicable and otherwise valid provision, the First Amendment has not been offended, right? So they just castrated the test. So they've said, if the purpose of the law isn't to stop the person from practicing their religion, it's incidental. It's just for everybody else, and it's incidental if this person can't practice their religion. That's tough. So now the Sherbert test's out for a while. So here comes Congress and says, we're going to put in the Religious Freedom Restoration Act and give some power back to this clause, right? It reinstated the Sherbert test, mandating that strict scrutiny be used when determining if the free exercise clause of the First Amendment to the Constitution is used. Okay, so you have to now go back to being strict. So now we're up to 97, right? And this is a Catholic church trying to expand a building permit, and they were denied. And they sued for this, saying that they should be able to. And the Supreme Court struck down RFRA as an unconstitutional use of Congress's enforcement powers. And because it was the court that had the sole power of defining substantive rights guaranteed by the 14th Amendment. So here again, they're back to saying Congress doesn't have the right to do this. You can't have a new act that you're putting in place just to reinterpret the Constitution and reverse what we've decided. They're exercising their power. Okay? All right, so a short break before I continue. I have some questions and I have a couple of rewards. And some of these I saw in a couple of the flyer that you had back there, so hopefully some of you know it. So, first question, when was the first use of In God We Trust on our coinage and bills?
Earlier than that.
What was it?
Was it official or?
First use, not when it became a law.
Okay.
Right after the Civil War sometime.
1890 something.
1890. So, close. Anybody else? 18 what?
97.
Before that.
1794.
No, you're in the 1800s somewhere.
1891.
Earlier.
1867.
Oh, that's getting close. So it was 1860.
Oh.
And there's a Buffalo nickel that doesn't have it on there.